And our presentation is on the implementation of Lagos State Administration of Criminal Justice Law, the progress, the challenges, and the opportunities for improvement. Firstly, I want to thank the chairman and also to the coordinator for this program, Turula, who has also given us the opening remarks as to why we are here today. And to everyone that is seated here, we are here to collaborate. We're here to give our own and other inputs as regards to this. So I'm going to read the Attorney General's remark and his presentation on the topic. So please, you're going to bear with me. There will be times where I'll have to pause a bit and give some explanation on when we are here. Thank you very much. So hopefully I do not pass 30 minutes, which I hope not. So we begin. The Lagos State Administration for Criminal Justice Law is a vital legislation designed to streamline and improve the criminal justice system in Lagos State. It aims to ensure fairness, efficiency, and the protection of the rights of individuals within the system. This law came into being in the year 2015, has now been amended in the year 2021, as the law must be dynamic to reflect prevailing circumstances in the state. In discussing about the progress of the ACGL, we cannot overemphasize the impact of the law as it relates to human rights and the accountability of the police to the state as a whole. This ACGL emphasizes the protection of fundamental rights of suspects and defendants, irrespective of whatever crime that is alleged against them. This includes provisions against unlawful arrest, detention, and torture. Now, for example, can we take a look at Section 4, subsection 1 of the ACGL, which was amended, where it states that a person shall not be arrested in lieu of another person in a criminal matter. And we know sometimes this does not apply. We see where some people have been arrested in trying to get the main suspects. And the ACGL has brought this out. We are not supposed to do that. And the law further states in subsection 4, a person or a law enforcement officer who arrests in contravention of section 1, which is arresting in lieu, commits an offense, is liable for misconduct. Now we can see, has this been brought to light? Has there been any officer or arresting officer brought to law stating that you have arrested somebody in lieu of another person? Now, another progress of the ACGL is the regulation of human treatment of arrested officers. Section 9A of the law states that a police should refrain from parading any suspect from the media. And if we look at some of circumstances or when some people have been arrested, we can see that some suspects are paraded on the media, faces are shown on the TV for offenses that or crimes are said to be alleged to be committed against the citizen. Their faces are plastered everywhere. Cases have not yet gone to court, and you are seeing the person's face everywhere. Now, going to Section 9 of the rights of the suspect says that it provides that clear guidelines for arrest procedures. Now we have guidelines which the police is supposed to follow. We have procedures, we have requirements that are to be followed when you arrest such persons. Now the ACGL has brought this out for each and every one of us to read in black and white. Now this law seeks to expedite criminal proceedings, reduce delay in the administration of justice. An objection which is taken at the trial court when the prosecution closes a case. So when a case is taken to court, we do this to remove unnecessary delay. When defendants are taken to court, it's best once you are taken, have your lawyer on standby, arraignment begins, prosecution calls the witnesses, defense calls their own, and we close and wait for the judgment of the court. So there are guidelines and procedures which has to be followed by each and every stakeholder in criminal justice system. Now, another progress of the ACGL is as it relates to plea bargain. Plea bargain is also one aspect which is encouraged by the Attorney General's office and to everyone, the defendant, the victim. It's just to restore peace at both sides. Where the office of the Attorney General is not interested in putting everyone in custody. There are other ways, there are other means which this can be done, and this is through plea bargaining. Now, the ACGL also introduces modern practices during court proceedings for witnesses who are out of jurisdiction or who cannot give evidence physically. And this is provided for in Section 200, subsection 1 to 3, which gives witnesses an opportunity to tell their story without physically appearing in court. And this is through virtual hearings, where links are sent to witnesses after you have applied to court that, oh, I won't be within jurisdiction, through your counsel. And here the person can be at the other side, give his evidence there, believing that the person is also in court, because you also have to coordinate yourself like you're in a court forum. So this is one of the progress of the ACGL. Now, furthermore, the ACGL has done this as regarding the recording of statements and the use of technology to enhance accuracy, transparency of the system by reducing the issue of involuntariness of statements raised by defendants when confessional statements are being tendered in courts. Now, the ACGL has stated that police should record statements of defendants when they are brought to the police station. This is to reduce when we have objections being raised as to being beaten by police, being treated unfairly when you want to tender their confessional statement. So the ACGL has brought back, you have to do a video recording of statements of every defendant that is brought to the station. Now, the introduction of the Lagos Criminal Information System, which is the LCIS, helps to create a database of persons who have come in contact with the criminal justice system. We now have a system where information of person in custody can be tracked, thereby reducing the awaiting trial inmate syndrome. This has helped in ensuring timely provisions of inmates in courts for speedy determination of cases, thereby reducing congestion in the final stage. The ACGL, we've also introduced virtual hearing in respect of inmates who have cases in courts far from correctional centers. In fact, the state is employing information technology to improve the criminal justice system. The ACGL law encourages the use of alternative imprisonments. These are in roles governing community service. Some of the purpose of this role is to reduce and decongest the correctional facilities and institutions, to rehabilitate and integrate convicted persons by making them undergo productive works and avoid mixing persons convicted with simple offences with persons of serious offences. This is stated in Section 347 of the ACGL amended law. Now, as we have stated our progress, we also have challenges, and this is where we go to. Now, one of the main challenges being faced by ACGL is the non-compliance of Section 9A by security agencies. The law has stated that no suspect should be paraded on the media, and there are reasons for this. For example, where the court finds the suspect not guilty and acquits him, what becomes of him? And this is where we'll now see different applications being brought against the police and brought against the Attorney General and Commissioner for Justice, when you have paraded the suspect's face all over media, and the court at the end of the day sees that there's nothing linking him to the alleged offense. Then such person realizes when he comes back to society, they still put in quotes, say, oh, yeah, still done this. But because of the supposed mistake that was done at the beginning, that will lead to a setback on the suspect. And when the court says you can go freely, the society sees him as a different kind of people, and now he has lawyers to back him up to go against the police and also to go against the Attorney General for placing his face all over media. Another challenge which is being faced right is we're making efforts to ensure that police officers conduct proper investigation and video, including recording of statements by suspects at the station upon arrest, in or in the presence of a lawyer. This provision of the ACGL we respect is in conformity with the international best practices. It helps in reducing allegation of torture or any inhuman treatment by police investigators. Lastly, there is need for more advocacy for the use of community service as a mode of punishment for persons who have been convicted by judges or magistrates of the judiciary, as this will decongest the correctional facilities and also make the convict a better person by giving back to the society. The burden of the society is that we desire good and better society, but are we ready to make these sacrifices? To have a crime-free society is impossible, but to reduce crime to the minimum is achievable, with people playing active role in ensuring that crimes are promptly reported and witnesses are available to testify in court. The police and the government cannot do it alone. It's only in a collaborative effort to ensure better society. Lastly, as the Honorable Attorney General, I will continue to uphold the rights of every citizenry in Lagos State, and also to continue to advocate to all stakeholders to continue to follow the procedures laid by the ACGL, which is one of our guiding tools as it relates to criminal justice system. In conclusion, I want to thank International IDEA and ROLAC for putting this town hall stakeholders meeting. We as the Office of the Attorney General will welcome suggestions and ways to improve our criminal justice system in Lagos. Thank you very much.